Displacement of minor children in Wisconsin always have to be 50-50. Many years ago it was routine that when a divorce was filed, absent some major issue or problem with the wife, such as substance abuse or mental illness, that she would get custody, and it was sort of standard that the father would see the children every other weekend and maybe one evening during the week. Both society and as a result the law has changed quite substantially from those days, and it's quite common now to see where placement of minor children is 50-50, sometimes exactly so, sometimes directly down the line, and we see placement agreements and orders by the court that can range from sometimes week on, week off, which has its own issues and problems, to much more complicated schedules. The law does not mandate 50-50 placement in Wisconsin. The statute says that the court is to maximize the time the children spend with each parent, which of course is mathematically impossible, because if you maximize with one parent, you minimize with the other. That being the case, however, there are many cases where 50-50 placement is appropriate. If neither party has any substantial issues with, say, mental illness or substance abuse, where there's no history of domestic violence, where both parents are capable of being good parents and geography doesn't otherwise prohibit it. In the majority of cases we see now, 50-50 placement works fairly well. And that includes cases where perhaps the father was not as involved as a parent as the mother was prior to the divorce, but the divorce and the separation triggers in the father a wish or desire to become more actively involved. This is not one size fits all, and there are cases where there's primary placement with either the mother and sometimes primary placement with the father. For your individual circumstance, you need to consult with an experienced family law attorney, find out how this statute and how the law and how courts' preferences affect your individual case.